We will call the last case for today, Selliman versus Colton. This is a 20-minute grant. Good afternoon.
Good afternoon.
You have 2 minutes of a free fire zone, and you may reserve time for rebuttal, but we ask that you keep track of that yourself.
Certainly do my best. Good afternoon, Madam Chief Justice, Justices, may it please the Court, Rachel Ratton on behalf of the plaintiff appellant Antonio Selliman. When I appeared before this court back in December of 2022 for a mini oral argument on the application, I borrowed a phrase that counsel in the companion case used to describe overruling Woodard as a nuclear option. And Justice Zara asked me if this court were to drop that bomb, if they were to overrule their precedent, what the rule should be. And I did the very cringy thing of listening back to my argument in preparation for this argument, and I was not satisfied with the answer I gave. So I'm very grateful to be back before this court.
That's why you're back.
It is. I'm grateful to be here, to have another opportunity to hopefully more clearly articulate why I think this court should exercise that nuclear option, why they should overrule the precedent of Woodard, and to offer what I think is the correct interpretation of MCL 600-2169 and how that should be applied in medical malpractice cases. In short, my proposal would be that the term specialty as used in the statute does not include subspecialties. I know we got into that a little bit in the companion case. The term board certified as used in the statute does not include certificates of added qualification. That when a defendant doctor holds multiple board certifications or practices in multiple specialties, there may be more than one relevant specialty for purposes of determining expert qualification, and that the term majority as used in the statute means the greater part of a whole and not necessarily greater than 50%, which is the current test under Woodard. This court, in its order, did ask the parties to address whether stare decisis weighed in favor of retaining Woodard. I'm happy to have a discussion about that, but I do have an awareness of this court's rulings in Kendall Al Sayed and Atkin, and I feel comfortable with the court's current approach to the doctrine. I know this court has recently overruled precedent when it has found a case is wrongly decided and defies practical workability. I think Woodard should go the way of those precedents and also be overruled. And to get right into what I think the test should be, beginning with 1A of the statute, the term specialty as used in the statute should not include subspecialties. That term board certified should not include certificates of added qualification. Very simply, I think this court should enforce the text of the statute as written. A subspecialty is simply not a specialty. Those words are not synonymous. There is no reason to believe the legislature believed them to be. This court in Woodard believed them to be, but it got there by adding words into the statute that simply do not exist. Equating subspecialties and specialties creates a number of problems, as exemplified in the companion case. Ms. Howard referenced a few of the issues that arise when a subspecialty is shared across multiple specialties. And she used the example of internal medicine. I chose sports medicine, which is a subspecialty of emergency medicine, family medicine, internal medicine, pediatrics, and physical medicine and rehabilitation. 5 different specialty boards. To say that the statute requires a subspecialty to be on the same level as a specialty creates an issue because a subspecialty can in fact be shared against or across multiple specialties. I do not think any defendant doctor who holds a board certification in pediatrics and a subspecialty in sports medicine wants to have his alleged malpractice critiqued by an expert who holds a specialty in physical medicine and rehabilitation with a sports medicine subspecialty. And I think that is something that would happen if you continue to conflate a subspecialty with a specialty. I think the best way to solve this problem is to adopt the definition of board certified that's found in the Public Health Code, which defines board certified as certified to practice in a particular medical specialty by a national board recognized by the American Board of Medical Specialties or the American Osteopathic Association. If you adopt that definition, you create a finite world of specialties that you have to match in these medical malpractice cases. I wanted to address Justice Viviano's question in the companion case about what we do with the fact that the ABMS itself wrote an amicus in Woodard and said subspecialty means specialty. I give credit to whomever wrote the amicus in Woodard, but I think it needs to be read in the context of how that came about. To say that it was, the reality is that that was written in 2005 or 2006, when Woodard was before this court. That's when the ABMS came forward and said to us, subspecialty means specialty, although they are different words. That came about in 2005 or 2006. That is not to say that at the time the legislature was enacting the statute and choosing the word specialty and specialty alone, the legislature believed that specialty meant subspecialty. They didn't make that decision in 1987, or probably earlier, 84 maybe, when they originally enacted this expert qualification statute. I think it's great that the ABMS said what they said in Woodard, but that doesn't give any insight into what the legislature was doing almost a decade before. So I don't think we really have to rationalize those two because they came at different points in time.
Are they terms of art in the medical field?
I do believe a specialty and a subspecialty are terms of art. I think that's why they are separate phrases. I tried to come up with some sort of an illustration.
Well, if they're terms of art, why would we not listen to the experts in the field about the meaning of those terms and whether the concepts mean two different things or for purposes of the statute should be considered the same?
Because I think we have to apply the words of the legislature. And the legislature presumably took in information from the ABMS, from these other boards, and made a decision to reject the inclusion of subspecialty in the statute. They decided the only term of art they wanted included in the statute was specialty, not subspecialty. And I would also say that the fact that the ABMS amicus believed that the term should be understood to refer to member boards of the ABMS, they say that in their amicus brief. They think the phrase specialty and subspecialty should refer to their boards because they are the preeminent certifying association. 90% of physicians belong to an ABMS certified board. The court in Woodard didn't accept that premise. The court in Woodard didn't say, we're going to define specialties only according to the ABMS. So why are we putting so much emphasis on what the ABMS amicus said in Woodard just because the Woodard court accepted one thing and rejected another? I think that goes to the fact that Woodard was wrongly decided. And this is the exact situation in my case, is that why I think you should have to limit this world of specialties to the ABMS is because in my situation, the only ABMS certified board at issue in my case is the American Board of Otolaryngology Head and Neck Surgery. That is the only ABMS board either of the doctors in this discussion hold. And each of those doctors had to first obtain that certification from the ABMS board before they could go to this outside ABMS board and pick up this other specialty certification of facioplastic reconstructive surgery. The fact that you first had to obtain a member board certification from the ABMS before you could then go obtain this different outside certifying board, to me, means we should define the world of specialties to ABMS or American Osteopathic Association member boards. And in a situation where a defendant doctor may hold more than one specialty board certification from an ABMS board, not a specialty and a subspecialty, but two distinct boards under the ABMS, I think this calculation obviously becomes more difficult. I would acknowledge that. First of all, I do not think that is a common phenomenon. I think it is common for physicians to hold specialty certifications from one certifying board and then to pick up multiple subspecialty certifications within that board. I do not think it's common for physicians to be double or triple board certified in separate member boards. I think the statistic is 20% that I saw. But if that defendant doctor exists, if there's a defendant doctor out there who has gone through the rigorous training, spent the time, spent the money to pick up 2 separate certifying boards, and if that doctor is sued for malpractice, then in that situation, you need to look at the treatment that is provided to ascertain which of those 2 boards may be relevant. And this is where the idea of the one most relevant specialty came from in Woodard, which I think is noble, but goes a step too far, and it's the test that really created a problem in my case. As the amicus brief in Woodard acknowledged, the statute requires the expert witness to match only the specialty which encompasses the treatment which the alleged malpractice arose. I think you always have to look at the treatment being rendered from which the alleged malpractice arose. I do not think you can just simply look at a specialty in a vacuum. I want to note that in this case, in his affidavit of merit, the plaintiff's expert physician, Dr. Armstrong, opined that the applicable standard of care is otolaryngology and facial plastic and reconstructive surgery. Defendant's expert, Dr. Karen, identically opined that the applicable standard of care, which is what we're concerned with under the statute, identically opined the applicable standard of care is otolaryngology and facial plastic and reconstructive surgery. In this record before the court, defendants have presented nothing by way of testimony, medical treatise, or really any argument that would suggest the standard of care for a rhinoplasty procedure changes depending on whether it's performed for cosmetic reasons or medical reasons or by an otolaryngologist or a facial plastic and reconstructive surgeon. Defendants have never challenged plaintiff's affidavit of merit or Dr. Armstrong's qualifications pursuant to court rule. Defendants did not attempt to amend their own expert's affidavit or in any way retract his previous opinion that the applicable standard of care is both otolaryngology and facial plastic and reconstructive surgery. Instead, rather than relying on the opinion of their own retained expert, defendants have unilaterally declared the applicable standard of care in my case is only facial plastic and reconstructive surgery. Truthfully, if we're concerned about matching apples to apples, in my case, my doctor is the same apples as the defendant. They have the exact same board certifications. The only difference between these men is presumably how they would self-describe their own practice areas. If you look beyond my case, where I do think it's easier, into a more complex case like the companion case, if the parties can't agree what the relevant specialty is, then I do think the trial court needs to make a further assessment of the expert's qualifications pursuant to the other subsections of MCL 600-2169. They can do it under the statute, they can do it pursuant to MRE 702. There are other provisions in the law to challenge expert qualification.
I asked this in the prior argument, obviously, would that matter if the standards of care differ? In this case, you're saying they were the same, so it shouldn't matter.
Correct. In my case, I don't think it matters. I truly
Right.
think this is
They were the
useless
same.
splitting of hairs. But I do not think, I'm not a physician. If a physician could articulate why this standard of care, what a reasonably prudent physician would do under the same or similar circumstances, changes based on what specialty you hold, I do think a trial court has to make more of an assessment of that. I do. If that can be articulated, I think that would be up to the trial court. But at the same time, because you have to apply the statute in totality, by the time you're getting to the point where you're looking at what is the relevant standard of care, what is the medical treatment at issue, you have to have already matched the board certifications. So, for example, an ABMS certified board, we can use my facts and slightly tweak them. There is an ABMS certified board for plastic surgery, just like there is an ABMS certified board for otolaryngology. I think in my case, if defendant Dr. Colton held a board certification in plastic surgery, and my plaintiff holds his ABMS board in otolaryngology, although those two men may both be performing a rhinoplasty procedure day in and day out, I can understand the defendant's argument that, hey, I hold a different specialty certification than you. I agree we both then went on and we picked up the same separate specialty from this separate board, but my original training is in a different specialty than yours. And for whatever reason, I presume he could articulate why that alters the standard of care that should be applicable to him, because he is board certified in plastic surgery and my doctor is board certified in otolaryngology. But as I said, I think by the time you're getting to really assessing that minutia of the malpractice, what is really going on, you've already cleared the first hurdle of, do these board certifications match or do they don't, or do they not? And the easiest way to do that is to only require the matching of specialties of the ABMS or the American Osteopathic Association.
So if your expert only, they matched specialties, but they only did like functional or medical rhinoplasties, not anything cosmetic. They never touched a cosmetic case.
So I think, and it's really a problem in my case, this division of cosmetic versus functional. And I truly do not believe that a physician who performs rhinoplasty could divide his practice in such a way to say, I have never once done anything cosmetic. And anytime I do a rhinoplasty, it is strictly functional. No part of cosmetics weighs into what I'm doing. All I am doing is something medical. I don't know how you could do that, because that would suggest to me that you could perform the same procedure in a different way if you said to your patient, my end goal is different. If I can make your nose look a certain way cosmetically that is not also okay functionally,
Well, what about the
I
flip?
can do it.
But the flip is, they could say to their patient, you have breathing issues, we're going to fix that, and cosmetically, it's going to have no impact. The work that I do doesn't look any different on the outside.
True, they could say that, except I think the problem there comes from the fact that 25% of, and this is in the deposition testimony of Dr. Armstrong, 25% of the otolaryngology board is focused on facial plastics. So they have picked up that certification. They had to get the otolaryngology specialty.
And that's all they need.
Yes, I do believe so. I think the reason I made the distinction, if Dr. Colton had a plastic surgery specialty and not otolaryngology, is because I can see, Chief Justice, your point of maybe you're coming from a different school of thought. You're looking at a different thing.
Like, almost like, as long as we don't mess up breathing, we can do whatever we want cosmetically.
I still think that doesn't really make sense under the standard of care, because I think that is doing harm to your patient, and I think on a baseline level that would never be acceptable under the standard of care. But I can understand if you came from a different medical school of thought because you had a different specialty and your specialty was only plastic surgery. I can't understand why that physician, that plastic surgeon, would say, I shouldn't be held to the standard of care of an otolaryngologist, although we are doing the same procedure. But I don't think you would ever get there, because your expert would be out under 1A, because they don't have the same board certification. So you'd never have to get there to make those distinctions. I doubt it's any surprise that just as I think the one most relevant specialty test of Woodard is inconsistent, I don't think Woodard's interpretation of the majority of professional time test is consistent with the language of the statute. I don't believe that's consistent because just like there's no language that says subspecialty, there is no language in the statute that says a doctor can only be engaged in the practice of one specialty at a time. No language that suggests a doctor cannot practice a specialty and a subspecialty. There's no language in the statute that mandates an artificial 50+% threshold, which is what grew out of Woodard.
You think that there's a different definition of majority?
Yes, I think majority is the greater part of all in that
Plurality?
situation. I'm sorry?
Isn't that plurality?
Yes.
You think the legislature knows the difference between the two words? Just like you say they know the difference between specialty and subspecialty?
I do, but I think the difference there is that subspecialty and specialty are distinctly two different words. They, in the definition of subspecialty, I think Ms. Howard maybe had mentioned it in her argument, it's a subordinate area of the specialty. They are in and of themselves different words.
But don't we can solve the problem of measuring the time if we're saying it all falls under the umbrella specialty, then it
probably goes well over 50%.
Correct.
Because you're doing two
It
things at
does.
once is the argument.
Correct, it does. But to get back to your point, there is an interpretation of majority that does not in and of itself mean greater than 50%. And the reason I think that's what the legislature intended is because they incorporated this language of either or both. And we briefly touched on it when we were here on the application. The legislature said when you're trying to evaluate this professional time requirement, the physician can spend their time in either or both active clinical practice or teaching. You cannot spend greater than 50% of your time in two separate things. I'm not good at math, but I know that if there's two things and you are doing both of them, one of them is not going to be greater than 50%. The best you're ever gonna get is 50 and 50. If you did 51 and 51, now you're at 102. That's beyond the 100%. The fact that the legislature said you can do two things at once, either or both, clinical practice and teaching, to make up your majority, to me shows you don't have to be greater than 50%. It just has to be the greater part of what you're doing.
How does that language inform your definition of majority? Legislature said a majority of, and then it says you can do it with
Yep.
either one, or you add them together to get to your majority.
That's where I disagree in the sense of you add them together, because the interpretation of Woodard now is you can't add anything together. I think the statute, that language would allow you to add them together because it says either or both. My issue is with Woodard, which would not allow you to add them together.
Clinical and teaching?
Woodard would not allow you to add, if you stay within the same specialty, yes, I think under a plain reading of the statute, you could say, I spend 30% of my time teaching plastic surgery, I spend 30% of my time practicing plastic surgery, therefore I'm at 100, or I'm at 60% of my time. The statute would allow for that, I would agree. That is why I think 50% or majority does not only mean 50%, because you're allowed to aggregate things to get to a majority of your time. And another reason I don't think the statute I don't think the legislature intended for this 50+% bar is because the legislature has enacted statutes also within the Revised Judicature Act where it does incorporate a 50% bar. It's in, had it written down, 629-12A, which discusses the loss of opportunity, and it sets a threshold that you have to be at 50%, greater than 50%. You have to have a greater opportunity to survive without the malpractice than you would have with the malpractice. The legislature knows how to say majority is 50%, and there is an interpretation of majority that does not militate a numerical value. And I think in this situation where the practice of medicine is so overlapping, where doctors have such a hard time dividing their practice between two different specialties or two different subspecialties, if we're going to continue to include subspecialties, I think to force this choice on medical professionals to artificially divide their time in a way that does not make sense practically is a fundamental flaw of Woodard. And I, of course, had many more things to say, but I see that I am out of time. So if there are no more questions, I will sit down.
Thank you.
Good afternoon. May it please the court. Jeff Garish on behalf of Dr. Colton. Since the court has already heard quite a bit of argument between the last time we were here and this time, although I have a lot to say, I'll waive the free fire zone. If there's any burning questions that your honors want to ask me, I'll try to field them. The basic problem they have in this case, and I've said this before, is their problem with Dr. Armstrong is not a problem with Woodard. It's a problem with the statute. In particular, it's a problem with the statutory amendments. Dr. Armstrong would have qualified under the pre-amendment version, which allowed an expert to testify as long as he specialized in the same or a relevant related specialty and spent not a majority, but a substantial portion of his professional time in the same or irrelevant related specialty. That's what they need. That's the criticism aimed at Woodward is really aimed at the statute. And that is why they cannot point to any of the several opinions in Woodward that gets them where they need to be. And I echo the point that Mr. Cook made in the last case. There are 7 unanimous decisions, 7 unanimous justices in this case. They all agreed on the points that are being challenged here. And that was at a time when those 7 justices didn't always agree on everything. It was a very thorough opinion. They all agreed on this. Now plaintiff is saying they were all wrong. They all missed the boat. But that's also why they cannot give you any way that Woodward could have been decided or written so as to be faithful to the statute and to qualify Dr. Armstrong. They haven't even tried, and the court asked them to do it in its order granting leave, and they didn't try because they can't. And even today, when you look at the things they've said as to where Woodward went wrong, none of them gets them anywhere in this case. I mean, the first point is they say specialty doesn't include subspecialties. Well, that doesn't matter in this case because as they've conceded, both otolaryngology and facial plastic and reconstructive are both specialties. They're not subspecialties, so that doesn't help them at all. They also argued about the board certification versus a certification of additional specialty. That doesn't matter either. These are both board certifications. It doesn't help them in this case. And then the last thing they said is majority actually means plurality. I have more to say about that, but that also doesn't help them in this case because Dr. Armstrong's own testimony unequivocally was that he spent 90% of his time in odor and ENT and only 10% of his time in facial plastic and reconstructive surgery. So even if you accept them that plurality, majority actually means plurality, it doesn't help them. Instead of arguing things that actually would help them in terms of how Woodward could be written, they've focused on other things that are irrelevant. Another one is they've talked a lot about how these are the same basic specialists. They both have the same 2 specialties. They're matching mirror image specialists. That's stipulated. The Court of Appeals said right in its opinion it's undisputed that they have the same specialties. Their position is basically that really ought to be enough. But the legislature didn't think so. The legislature put in another requirement, a separate requirement that says you also have to spend the majority of your professional time, you have to devote it to the same specialty as the defendant. And they actually changed it, which I think is important. They amended the statute, which had said only that you need to spend a substantial amount of time. When they changed that to a majority, I think it made it crystal clear that the legislature needs you to spend most of your time in the same specialty as the defendant. And I would just add this, with all the criticism that Woodward has received, it seems especially ungrateful given the fact that Woodward interpreted the statute in a way that makes it really about as easy as possible in terms of what the statute required. The court could have adopted the concurring opinion that required them to match all specialties, but they didn't. They adopted the version that says you just have to match the one most relevant specialty. That's it. This isn't exactly an onerous burden for either the plaintiff's bar or the defense bar. Find one expert that matches the one most relevant specialty. That's all you have to do. Woodward held that while there can be multiple relevant specialties, there can only be one most relevant specialty. That's axiomatic. I mean, that's just basic English. It's the meaning of the word most. There's only one. Specialist is used in the singular. Woodward also correctly interpreted the statute to require an expert to have devoted a majority of his or her professional time as opposed to a substantial portion of the time. The other point that was brought up today, and I'm glad it was, because Justice Kavanaugh, I gave you what I think was a less than stellar answer last time I was here when you asked me about what about the either or in the statute. What that means is the legislature allows an expert to aggregate time spent in practicing or in another profession of teaching. They can aggregate that time, but they cannot aggregate time in different specialties. The legislature could have done that. They could have said either or in the context of aggregating specialties, but they didn't. They said you can spend a majority of your time in either or teaching or practicing in the same specialty as the defendant. And that aggregation of the professions means, if anything, that they intended not to aggregate specialties. The other thing that Woodward recognized that I think is helpful is that, and this is in Justice Markman's opinion, is that the trial court decides what is the most relevant specialty. Sometimes I think that can probably be difficult. Justice Welsh, you asked me a pretty tough question last time I was here. Am I practicing as a med mal lawyer, as an appellate lawyer? And I think I agreed I'm doing both. And that's probably true in the sense, and certainly the negligence section talks about this, a specialist in pediatric oncology is also specializing in pediatrics. But there is one that's most relevant. And even if it's a difficult call, the trial court makes the call, and that decision is reviewed for an abuse of discretion. And that's the way it should be. And I note that my sister counsel said that at one point, it was that we decided that the most relevant specialty is facial plastic and reconstructive. But it wasn't us that decided it. It was the trial court that decided that. That was the trial court's decision. That the trial court got right. Where the trial court got it wrong was in interpreting Dr. Armstrong's testimony as being equivocal on whether he spent 90% of his time on ENT versus facial plastics. He was unequivocal on that. He testified to it 3 different times. And the Court of Appeals quoted his deposition testimony, and I think it's important. The first time he said it, he said there's some overlap. But then he was asked specifically, can you give me an approximation of currently the breakdown of your practice, general otolaryngology versus facial plastic and reconstructive? And he said 10% maybe in the facial plastic realm, and 90% would be considered medically ENT. And then he said it again. It's in the Court of Appeals a second time. But from 2015 to 2017, he said it unequivocally, 90% in ENT, 10% in facial plastic and reconstructive. Where they're finding confusion is later in the testimony. The lawyer, defense counsel, asked him, how do you divide the time spent within facial plastic and reconstructive surgery as between cosmetic and reconstructive? And on that, he said, that I don't know, and I'm not sure how he would know, because cosmetic and reconstructive, that, of course, is going to be a lot of overlap, but that's all within the umbrella of facial plastic and reconstructive surgery. That's what they point to as supposedly equivocating, but it doesn't equivocate at all. He had already addressed the issue of how much time was spent in ENT versus facial plastic and reconstructive surgery. So the trial court got that wrong, but did get it right in finding that the most relevant specialty was facial plastic and reconstructive surgery. Here's another point I wanted to make, which addresses not only a comment that Ms. Ratton made, but something that was in the negligence section's brief that was filed last week. They said their main thrust is that there should only be the 24 specialties, and they should all fall under those umbrellas. But the reasons articulated in the last argument, and really in the AMA's amicus brief in Stokes, I think gives a very good explanation why specialty has to mean subspecialties as well as Justice Viviano pointed out, ABMS's own words said that a subspecialty is a specialty, so I think that's correct. But the negligence section, they say that all 7 justices were wrong, the ABMS is wrong, and we're right. It should only be these ones. If anything, the heightened specialization in the medical world makes it more apparent that you should be focusing on more specialization. And it's even clearer now in 2023 than it was back in '93 when this legislation was passed, 30 years ago, without any amendments, I would add, or in 2006 when Woodard was decided. But the way the negligence section tried to argue that our Court of Appeals got it wrong is really with kind of a sleight of hand maneuver. If you read their brief, what they said happened in Selliman was that there's only one ABMS board, and that's otolaryngology, and so that's the one that should apply, and then facial plastic and reconstructive surgery is a more specialized version of that. But what they didn't tell the court is one of the other 24 boards of the ABMS is plastic surgery. They didn't mention that. Well, it seems to me plastic surgery is at least as relevant a practice specialty as otolaryngology when you're talking about doing a rhinoplasty. They didn't mention that. But both, whether it's, and Ms. Ratton said it today, otolaryngology is the only relevant ABMS board. It's simply not true. Plastic surgery is also relevant, but the most relevant specialty is facial plastic and reconstructive surgery, as the trial court found, which was well within its discretion, and as the Court of Appeals affirmed. And the only other point I wanted to make, or at least one other point I wanted to make, and this is something I talked about in response to a question from Justice Welch last time, which is, this case doesn't just involve a single rhinoplasty or even a series of them. It involved a decision to proceed with one rhinoplasty after another, 7 of them, and then even in an 8th, which the plaintiff decided not to do, all of which were designed to improve his appearance. It also involved decisions to inject steroids, numerous steroids, on multiple occasions, and that's right in their complaint. And they talk about this long pattern of activity as constituting negligence. Well, the specialty clearly is facial, plastic, and reconstructive surgery. An otolaryngologist might know how to do a single rhinoplasty, but in terms of the standard of care in this case, clearly the more specialized specialty and the more relevant specialty is facial, plastic, and reconstructive surgery. And it's really not even close. And then I guess the last point I would make is as far as stare decisis, I thought Dr. Swafford's brief made a pretty good point that Robinson and Chief Justice Kelly, I think in the Peterson case, had said this, and it was in his brief, that Robinson had been cited 31 times when she decided that, never once to uphold precedent on the grounds that stare decisis should control. And then he mentioned 8 more decisions since then that have cited Robinson, only to overturn precedent. So that's 39, and there have been a couple more from this court this term that overturned precedent. Over 40 decisions that are consistently overturning precedent and citing Robinson to do so, when the preference should be to uphold precedent, even if it's wrongly decided. And I think this case, as much as any case, the precedent should be upheld, even if the court thought Woodard was wrongly decided, which we don't think it was. Certainly it wasn't wrongly decided in a way that Ms. Ratton has identified is relevant in this case. But even if the court thought it does, there have been very heavy reliance interests. Dr. Swafford didn't really think there had been. I disagree with him on that. I think there have been. I mean, in terms of naming experts, parties have been relying on it for almost 20 years, and it hasn't proved to be unworkable either. I mean, for 18 years, it hasn't proved unworkable in any sense. The only complaint that we're getting is essentially people claiming that it's too hard to name an expert. It's too hard to find an expert. But that's a beef with the statute. That's a complaint with the amendments to the statute, not with Woodard's interpretation of it. You haven't received any interpretation of Woodard, again, that would be faithful to the statute and that would allow Dr. Armstrong to qualify. And then the only other point I want to make on stare decisis is, even if you look at some of the Court of Appeals concurring opinions and comments on how Woodard needs to be revisited, other than the clarification that Mr. Cook talked about, the other criticisms that Woodard has received, again, even those really are aimed at the amendments to the statute more than they are to Woodard's interpretation of it. I've never seen in any opinion a proposed interpretation of the statute that's faithful to the statute that's inconsistent with Woodard. I mean, it just doesn't exist. In fact, even in this case, it seems like I've been going a long time. I don't know. Even in this, and I know the court it's been
You're
a long
like,
day.
please, somebody ask me a question.
I'll be fast. But even in this case, the judge that dissented from the order that granted our app for leave dissented on the grounds that both a an ENT doctor and a facial plastic and reconstructive surgeon know how to do rhinoplasties. So the one most relevant specialty rubric doesn't apply. It's logically inapplicable. That's the phrase that was used. But again, that's just a criticism of the statute, plain and simple. It's all it is. The test does apply. It is applicable. And they might not like it, but it applies. And a dislike of the legislation is not a basis to overturn it. I know this court knows it can't overturn legislation in opinion. Woodard did not misinterpret it. Woodard was decided correctly. There's no reason to overturn Woodard. It would be a bad idea to do so, as Mr. Cook pointed out. And there's certainly no basis to overturn the Court of Appeals' decision in this case. They really haven't even made any argument as to how the Court of Appeals got it wrong in this case.
Can you address real quick whether you think it's a problem or how it's handled, the problem identified where you have a subspecialty that is shared across multiple specialties? And then if we're treating specialties and subspecialties as the same thing, you could have the ridiculous, in theory, you know, I forget what the, sports medicine and this specialty in sports medicine, you know, an expert in sports medicine in a completely different specialty, completely different training, being under Woodard qualified to be an expert.
Well, yeah, there are different types of problems you can imagine, and the statute, especially as interpreted Woodard, but irrespective of being interpreted by Woodard, requires a matching of the specialty, so it's limited to one. And the problem with, I hope I'm answering your question, the problem with saying there's only these 24 specialties and the subspecialty is not a subspecialty is you have people that have, like a cardiologist testifying against an oncologist, which just makes no sense.
I think what the thing is, what if you have a subspecialty of sports medicine, but the defendant has that subspecialty under the specialty of, I don't know, pediatrics. Say, I'm looking at her. I don't remember the list of 5. And the expert has the same subspecialty of sports medicine, but under a different specialty. But the subspecialties match, and that's okay, even though they're not at all in the same relevant field or
I
training.
think it would be fact-specific. It could depend, and this is a decision for the trial court, and it might make sense in some cases to find that they match, even if they come from different umbrellas, if they're similar enough practices. But this is up to the trial court. It's a decision that's reviewed for an abuse of discretion. And I'm sure there are lots of tough situations you could come up with in terms of hypotheticals, but that's why I think it's important that the trial judge has discretion to decide what's the most relevant specialty, and there's probably some wiggle room in some areas where it's not obvious what the most relevant specialty is. But since now you reminded me of one other thing, I apologize, I wanted to say, because she mentioned Dr. Karen's affidavit. What happened with that is they filed an affidavit of merit and identified the 2 specialties and said, I spend most of my time in these 2 specialties. They can do that in an affidavit. They can aggregate them. There's nothing illegal about that. And then our Dr. Karen filed a mirror affidavit, the affidavit of meritorious defense, and matched the 2 specialties. I spend most of my time in these 2 specialties as well. There's nothing wrong with that in terms of affidavit of merit, affidavit of meritorious defense. But when it comes to determining the qualifications of an expert under 2169, now you have to have the one most relevant specialty. So the affidavits really have nothing to do with it.
So, okay, before you go. So what if there's a subspecialty, but it's just not something that comes up frequently? I can't think of anything off the top of my head, but it's something that there's people who have the bigger category, and then you've got these subspecialties, which I realize here, there's a bit of a different fact pattern, but, and every doctor in the state only practices in that subspecialty 30% of their time. So nobody is qualified to be an expert?
It seems implausible. I'll just say 2 things. I suppose it's possible under the legislation, and that again is a criticism of the legislation. I don't know of it ever happening in any decision, which suggests that it's not very plausible. The problem, again, is the use of the word majority. I mean, maybe in a hard case, a court could find that a plurality is enough, and I don't know if they get affirmed or not, when majority means more than 50%. But it's not a criticism of Woodard. It seems like a criticism of the legislation as amended. That's about the best I can do with that.
Yeah, it's an interesting conversation. Like, I recognize, to the Chief Justice's point about the definition of majority, but I also know sort of in lay people terms, when we talk about how we spend the majority of our time, if I were to say, what did you do last weekend? How did you spend the majority of your time? I bet it's not an actual 50%. It could be, but sometimes not.
Yeah, I think using the word in the statute, we assume it's carefully chosen and it's not, colloquialism. I think majority means majority. That's the natural meaning of the word, I think, is the problem that they've got, again, with the statute, not Woodard.
Thank you.
Thank you, Your Honors.
Thank you both. The case will be submitted, and we are adjourned until tomorrow morning.